prepare bench memos, and the courts will read the bench memos, and maybe they have time to read the briefs. In the Court of Appeals, as some of you know who have worked for us in our externship program, we read each and every brief. We try to be really prepared, but it's never enough time. And nobody knows the case as well as you do. Yeah?
How much gamesmanship is going on between the judges when asking questions to try to get another judge to flip their opinion?
That's a good question. My sense of it is it depends on the court. On the Court of Appeals, not much. We have talked about the case in the morning before oral argument for about a half an hour. Then after oral argument, we will talk about the case for as long as it takes for us to come to a straw vote and then assign the cases. We've also talked about the cases usually informally before argument. And we don't, there's only 3 of us, and we don't need to do a lot of cross-talking to one another. And we're also pretty pressed for time. We'll hear 10, 12, 15 cases in a day. And so there really isn't that luxury. My experience is in the Supreme Courts, when you have 7 or 9 people on a panel, and particularly when life on a court is more formal, there may be a little bit more of that. My observation in the U.S. Supreme Court is that there's some cross-talking going on between the members. I have no idea how efficacious that is. I don't know if it really works. I don't know if it's just the judges kind of posturing to one another. But it does happen. I've seen it in the Oregon Supreme Court occasionally when somebody will ask a question, and when one judge will ask a question and the lawyer doesn't answer the question quite the way that another judge wanted. And the judge will say, well, that's real interesting, because I thought your answer would have been, and then supply the answer, and as often as not, the lawyer will go, that's it, that's exactly, right? Occasionally that happens. That actually happened to me. I tried to slip in, you don't ever do this, I tried to slip in an argument based on a subsection of a statute that we hadn't cited in our briefs. And Justice Scalia called me on it. And I tried to kind of dance around it, and he wasn't hearing anything of it. And Justice O'Connor threw me, a little lifeline. And she said, oh, well, I thought that that the statute was implicitly blah, 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 blah. I went, exactly, Justice O'Connor, that is precisely what I intended to say. And Scalia just went, blah, blah, blah. If you look at the transcript, it says unintelligible. There's an interesting tradition because the transcripts never identified the names of the justices who were questioning. There is a kind of game that counsel will play in trying to work in the name of the justice in your answer. So if Justice Kennedy asks a question, it's only going to say court on the transcript, but it might say Landau answer, that's an excellent question, Justice Kennedy, blah, blah, blah. And that way, posterity knows who it was that asked that question. And so I did a moot court once, and my judges had little name plaques, and they were each of the 9 justices. And this was just after Clarence Thomas was appointed or confirmed. This was in January 1992. And in my moot court, Clarence Thomas, uncharacteristically, actually asked me a question. And just showing off a little bit to my moot court people, I said, that is an excellent question, Justice Hill. And you see, you're all too young to know about Anita Hill, whose allegations of sexual harassment were the subject of weeks of hearings in Justice Thomas's confirmation hearings before the Senate. And so my coaches were saying, Your Honor, it's perfectly fine. You don't need to worry about the names. Don't sweat it. Don't try to show off or anything. But I managed to work in a couple of names and got them right. And fortunately for me, Justice Thomas didn't ask a question. I think this was when he didn't ask a question for like 2.5 years. Other questions? Okay. The judges need help. That's why they're there. This affects what you do when you write your briefs, by the way. Your briefs should always be written for somebody who doesn't know anything about your case. When I write opinions, I try to write opinions for people who don't know anything about the case as well. I just think that's a really important tactic in advocacy. You never know if your judge, what is the topic of your problem, if it's a search and seizure problem, if it's an antitrust problem, if it's an unfair trade practices act problem. You don't know if your judge is going to be particularly expert in that subject, and it is always beneficial to assume that your audience isn't an expert. Doesn't mean you have to insult their intelligence, but it means that you have to lay it out, don't take anything for granted, connect all the dots, make it easily understandable to somebody who doesn't have all the expertise that you do. What it means is when you get to your briefing, your briefs should be brief, right? There is a reason why they call them briefs once upon a time. Although, as Ambrose Bierce in his Devil's Dictionary said, only lawyers can write 50,000 words and call them brief. You really don't need, if you have a 50-page word limit or 50-page limit, it doesn't mean you have to write 49.5 pages. You write just enough that is necessary to cover it. Important stuff first. Lawyers fancy we fancy ourselves good storytellers, and that may be great sitting around the bar telling stories, but it's not a good tactic for writing briefs. You don't want to wait, build a sense of dramatic tension, keep the key facts for page 24. You don't need an aha moment when you're writing the briefs. Everything should be set out so that in the statement of the case, a judge can read the first page or two and know anything he or she needs to know about that case, right? There's no penalties for giving away the ending. You want to put it all right up front, make it easy for the court to understand. Copies of pertinent statutes. I'm always intrigued when I have a brief in which the critical issue is about the meaning of a contract provision, and a party's brief doesn't include any of that contract language. It happens, and it kind of makes you wonder what they're afraid of me knowing. All right, so you want to spell it right out there, put it right out in front. Here's what we're fighting about. It can mean this, it can mean that. Don't hide it, be helpful, don't take anything for granted. Don't use footnotes. This is a personal pet peeve of mine. If God had intended us to read footnotes, he would have put one eye on top of the other, right? It's the visual equivalent of writing a pogo stick, right? I mean, think about it. Is it a helpful way to communicate information? Ask yourself, if you're writing a brief, if it's footnote material, could I leave it out? Or is it so important that I probably ought to put it in the text? It's usually one or the other. Footnotes, in my experience, unless you're just talking about truly marginal information that may be of use, citation information, subsequent history, renumbering, things like that, usually is because the writer is too lazy to try to figure out whether it ought to either go in the text or not at all. Yeah?
You know, with respect to looking at like contract language, for example, is it useful to put like the entire text of the contract in an appendix if, you know, only certain portions are necessarily relevant to the dispute?
Yeah, there are two answers to that. One is the critical language should always be right up front in the brief. The court shouldn't have to work hard to find it. Because all language is contextual, you want to put